This is St. Louis on the Air from St. Louis Public Radio. I'm Sarah Fensky. Bayer wants the U.S. Supreme Court to solve its Roundup crisis. Will the court come to the rescue? An Elvis-loving judge wants to cancel the deal he made to resign. Is he right to suggest he had no idea his retirement plans would become an international joke? And former St. Louis Circuit Attorney Kim Gardner says she relied on advice from a top lawyer when she used taxpayer money to pay off fines assessed for previous ethics violations. Does that excuse matter legally? These are all questions for a good lawyer. And today, I'm joined by 3 good lawyers willing to take their best shot at answering them and a whole lot more. Yes, today is our Legal Roundtable. And joining us today is Javad Kazali. He's a former federal prosecutor and founding member with the St. Louis firm Kazali Wersch. Javad, welcome back.
Thanks for having me back.
And we're also joined today by Mark Smith. He's a former vice chancellor and dean of career services at Washington University. He's also one of the founding attorneys of this Legal Roundtable. Mark, we're so glad you're back with us.
Hey, good to be back.
And last but never least, joining us today is Nicole Gorofsky. She's a former prosecutor in both state and federal court. She's currently a partner at the Clayton firm Frankel, Rubin, Klein, Payne, and Podlowski, PC. That is a mouthful. Nicole, thank you for joining us.
Thanks for having me.
So, Nicole, I want to start with you today. Bayer has been staring down a legal morass for a few years now. When the German company purchased St. Louis-based Monsanto, this was back in 2018, it acquired not just the weed killer Roundup, but also liability for that product. There have been now a shocking number of lawsuits claiming that Roundup has caused cancer. By the company's own count, 56,000 of them, and some have brought back staggeringly high jury verdicts. Now Bayer is appealing one of those jury verdicts to the U.S. Supreme Court, and the Trump administration has filed in favor of that appeal. So, Nicole, for those of us who haven't followed all the push-pull on all this, what is their legal argument to the Supreme Court?
All right, first, it's important to understand that the United States is not actually a party in the case. What they've filed is an amicus brief, which is basically a friend of the court brief, meaning that they're issuing, they're inserting their opinion even though they're not a party to the case. So that's the first issue. The second issue is there's a local Missouri hook in that the U.S. Solicitor General, John Sauer, who is from Missouri and did some legal work in Missouri.
He's from St. Louis.
He's from St. Louis. Is the person who wrote this amicus brief. So basically what the amicus brief says is that the EPA has a law, which is, I think, called the FIFRA. It's the Federal Insecticide, Fungicide, and Rodenticide Act, which requires certain warning labels. Basically, the point of this law is when a pesticide is going to be used and needs to get approval from the EPA looks to see if it has deleterious effects on the environment.
Sure.
And so what happened was the EPA allowed this specific Roundup pesticide to be used. And so what they're saying is just the fact that the EPA said that this was okay mean that people can't sue for negligence or other kinds of issues based on being harmed by this pesticide. So that's the issue that we're talking about. And that's the issue for the Supreme Court to decide whether that federal law preempts other types of lawsuits on Roundup.
Could literally preempt 56,000 lawsuits is the theory here.
Yeah, that's the issue to be decided, yes.
So,
and
Mark,
it would preempt them in all 50 states,
not just a Missouri thing. Wow.
Yeah. So in the Constitution, we have the Supremacy Clause, which says federal law trumps state law. And here in this statute, they said that the FIFRA, I think that's what, like you said,
FIFRA, I like
preempts any statutory or common law rule that would impose a labeling requirement that diverges from that. So they preempted. Now, whether that means they preempted all tort actions. That's their argument, and I'm sure the plaintiffs will argue the other way. Another thing, because I hear this a lot from people, they're like, why did Bayer buy Monsanto and buy all these lawsuits? And, when I was a practicing lawyer a long time ago, I would, for a little while, did corporate work. You'd do your due diligence. You'd go out, read all the lawsuits, and you'd kind of assess the value. So, I wonder, too. Did they miss this? Did they really underestimate it? You had to kind of see this coming down the pike.
You get why one couldn't have read 56,000 lawsuits, but you'd think somebody would say, "Oh wow, there's an onslaught
if you're a lawyer at a big firm
coming."
And this much money, you would read 56,000 lawsuits. You would read them all, and you're getting paid by the hour.
Thanks for the reminder of why I did not go to law school. I appreciate that all you guys did.
And you would read them in a room with no windows, like
you're
12
killing
hours
me.
a day.
You're killing me.
Till midnight.
Javad, I've got a legal question here. I'm going to spin this one to you guys. So this case that Bayer has chosen to appeal to the U.S. Supreme Court, that John Sauer is trying to get the federal government in on their side, this case involves a St. Louis man that sued in the St. Louis Circuit Court. Just a $1.25 million verdict. Bayer has much bigger verdicts pending against it in other jurisdictions. Why do you think they chose this one to take this one up to the Supreme Court?
I think one of the arguments is going to be that we're not looking at the size of the verdict. This is so small that even the jury didn't think it was that big a deal. But I think that this position is kind of terrifying. The plaintiff's attorneys made specific arguments. They said, there was a label in tiny, tiny print that said maybe this could be bad. But then you went out and Roundup advertised about how safe their product is. And people saw this. And they saw the videos of the suburban mom spraying this with the kids in the background. And they sold it this way. And this idea that you can have tiny, tiny print that is put on something, and then you have to rely on that. And that keeps you from being able to sue when you're hurt. This could affect lots of things. And I also find the irony of this, that the Trump administration is saying we have to protect big agriculture, because you have to trust what the government says about science. And at the same time, they're trying to open up a path so that anybody can sue the pharmaceutical companies over the COVID vaccines, which the Trump administration's science people approved. It doesn't make any sense to me. It seems like if you strip away all of the legal arguments, this is quite simply, this administration wants to protect corporations over the citizens. And this is the reason why you have juries, right? A jury went and looked at this case, listened to weeks of evidence, could have ruled against Monsanto or Bayer, could have given the client $100 million. They looked at this, weighed this, and gave $1.25 million, which is a rounding error for a company like Bayer. So why are we constantly not trusting the citizens and trying to strip this away from the courts and juries?
But the issue here is, it's not a factual issue. It's this interpretation of law, and you can agree or disagree with it. There's a split in the circuits. That's another reason I think this case is going, I think it's like the Ninth Circuit and the Third Circuit. They've got different results. So I think there's a chance the Supreme Court could take it. And also, our Supreme Court seems very pro-business right now. But this preemption argument is also the reason, like, you can't sue cigarette manufacturers. If I smoke and get cancer, they're going to say, even though state law would allow me, and I could maybe make a really sympathetic case, they're going to say, well, the federal government said we're going to allow cigarettes to be sold. We're going to put this warning on them, and it's gotten worse and the warning more intense. But that's going to be a shield then for these kinds of lawsuits.
So there is some precedent that Bayer could get a shield on this. You're saying this is not out of the blue.
I mean,
this idea.
I think this Supreme Court, if they pick this case up, this is bad.
We can agree or disagree whether we think it's a good idea, but I think this is a very viable legal argument, I think.
And Javad had mentioned the idea that this could affect lots of things. What else would you see this maybe affecting?
Well, I mean,
if Bayer's argument stands.
Yeah, so any kind of chemical or something that has some kind of federal protection. Like I said, we've done this with tobacco litigation. That's why it stopped.
But we could do this with chemicals we haven't done it for, basically.
Yeah.
Okay.
If there's some
Anything
kind of
with a
federal
warning label.
Yeah.
So do you think the Supreme Court cares that the Trump administration has weighed in on that? Does that affect their interest in saying, we want to give this a full airing?
Yes.
I think so, too.
I'm going to act like a state senator here and say 100% yes. Yeah, I think the Supreme Court cares very much about the Trump administration and what they care about. I think we know that there's been a symbiotic relationship.
But even outside the Trump, I mean, anytime you have the Solicitor General
That matters.
weighing in, I think they say, well, the government cares about it, and we got this split. He points to that in his filings. But yeah, they seem to care about the Trump
Siobhan, do
administration.
you see any world in which this St. Louis guy with his $1.25 million verdict, that he can go up against the big guys and that he can beat Bayer, that he can beat the Solicitor General, and that the Supreme Court is going to say, actually, you can't have these lawsuits?
Sort of. Okay. I think if the Supreme Court accepts this case and moves forward on this, he's most likely in a bad place. But, we've got a case right now that we put in front of the Supreme Court with Officer Milton Green, who was shot, by another officer. And I think we got a pretty terrible Eighth Circuit decision. And we hired some of the best attorneys in America that are in front of the Supreme Court all the time. And what they told us is so many cases are put in front of the Supreme Court that even with a case that we have with the circuit split, we've got about a 1% chance that they'll hear it.
Wow.
So if the Supreme Court, when they grab a case, it's almost 70% of the time that they're grabbing it because they want to overturn what was said before. So if they grab this, bad times. If they don't, and I don't think that they've granted cert on this yet, so the best case and most likely outcome is that the Supreme Court will just ignore it and let the verdict stand. But it also is very indicative of where the Trump administration's head is when it comes to corporations versus people.
So for people listening out there, you may have a question or comment for the lawyers that we have in front of us. They can't necessarily talk about the science of Roundup. They can talk about how that plays out in the law. You can call us at 314-382-8255. That's 314-382-TALK. Nicole?
I was going to say the other thing about, whether, the person with the smaller verdict will get good representation in front of the Supreme Court is that if the Supreme Court ends up taking this, think of all those 56,000 other plaintiffs that are going to want the right result in this case and are going to have lawyers coming out of the woodwork.
Can they band together and say, we want to make sure that the best possible people are okay? So this guy who's I think of as the little guy, there's going to be some big guys fighting for him too.
And they could also file amicus briefs, when you see a big case before the Supreme Court, and as Javad said, I mean, the Supreme Court in a good year takes 100 cases, and they get thousands of applications. On a big case, you'll see tens, if not hundreds, of amicus briefs from law professors, trade organizations, MATA, probably, people like that would do it. So
yeah, there's going to be a lot of backing for this guy up there, but if they take it, I think the writing's kind of on the wall.
Do you think that analysis is right? If they take it, the writing's on the wall.
I really hadn't thought about it, but yeah, that makes sense. It probably, and I mean, this court has been very pro-business, so I think, yeah, it probably would be bad.
If they take it, they'd want to take it to
be
save
very good
Bayer.
for Monsanto, and Monsanto stock shot way up just on the filing of this amicus brief from Solicitor General. Can you imagine what would happen if, you have oral argument there?
Yeah, I'd love to see, the buying and selling of Bayer stock within people in the Trump administration. When this, I bet you there were some people who were very predictive of this in the last few days.
Well, that's an interesting theory. I hope some
Somebody's
investigative
a little jaded
journalists.
over there.
Yeah,
That's a hot take.
yeah.
It's not jaded. It's happened repeatedly.
So, Nicole, we've talked about these 56,000 lawsuits over this product that are pending. If the Supreme Court were to come in and rule for Bayer and say, because of this warning label, you can't sue for negligence, you can't sue for these certain sorts of things, are the majority of these lawsuits then completely dead in the water?
Yeah, I think they are. I think that's the consequence of a United States Supreme Court ruling.
Wow. So this has huge consequences. I want to mention another piece of litigation involving Bayer that has much smaller consequences, but still potentially millions of dollars worth of consequences. Bayer is also suing its insurer. This is AIG. Mark, this seems like
it's a pretty pedestrian
contract
dispute.
issue.
Yeah, so it'd be like Nicole was saying before, you'd have to read the contract. What does it say? When did the occurrence happen? They'll argue about that. And it's like very much in the weeds.
I read some journalist coverage of this, and there was a professor at UMSL who said, this is a fascinating case. And I was like, is it a fascinating case? The other case feels a little more fascinating to me. Javad, do you see anything big at stake with the AIG lawsuit?
I mean, fascinating for somebody who's into this is great. I think, some of the other stuff that we're talking to is more up my alley when we start talking about judges dressed as Elvis. But anytime you have, whenever from a plaintiff side, I sue somebody, the thing I'm most interested in is their money, right? Because why are you going to spend years to do this if there's no money at the end? And the interplay between the defendant and insurance is always really important. So I don't know if it's interesting, but it will be informative, and it'll kind of direct us on how to deal with these things.
I think in all fairness to that professor as well, I think they were talking about just the scale of the amount of money was what was interesting.
Yeah. Javad has helped us with a good transition here, and we do have to take a quick break. I do want to mention we have a caller named Dwight who made a pretty good comment. He says, Roundup was originally created for industrial use and not commercial. Interesting to think about how that all changed and the repercussions still afoot today. We are talking to our legal roundtable. That's attorney Nicole Gorofsky, also joined by Javad Kazali and Mark Smith. We'll be back in just a moment to get back to our legal roundtable. This is St. Louis on the Air on St. Louis Public Radio. Welcome back. I'm Sarah Fensky. I'm in for Elaine Cha because today is our legal roundtable. Once a month, we get together and pick the brains of some of the brightest lawyers in St. Louis. I'm pleased that we have three great ones with us here today. That includes Mark Smith. He's a former vice chancellor and dean of career services at Washington University, one of the founding attorneys of this roundtable. Also joined by Nicole Gorofsky. She's a former prosecutor. She's now a partner in the Clayton law firm Frankel, Rubin, Klein, Payne, and Podlowski, PC. And of course, we're joined by Javad Kazali. He is a former federal prosecutor and an attorney and founding member with the St. Louis firm Kazali Wersch. So Javad has just been itching to talk about the Elvis-loving judge, and we're going to transition from Bayer and the life and death questions now before the Supreme Court to talking about a local judge who has become somewhat of an international laughingstock. This is Matthew Thornhill of St. Charles County. He came under fire for wearing an Elvis costume and cracking jokes in the courtroom. He agreed to an unusual deal where he would take a 6-month unpaid suspension, come back for a year and a half, just enough to collect his retirement. But now, Matthew Thornhill says he's the victim of a vendetta by the presiding judge in St. Charles County, who's good friends with the attorney who serves as general counsel of the state's Commission on Retirement, Removal, and Discipline of Judges. This is all according to Matthew Thornhill's theory. The Judge Thornhill says he agreed to a stipulated resolution that was supposed to keep his resignation confidential. Then the commission not only made its filings public, but also embarrassing photos of Judge Thornhill dressed as Elvis. This made international news. Judge Thornhill says the public release was a, quote, material breach of the agreement he reached with the commission. Mark, this was filed in the court docket. I was one of the first journalists to cover these Elvis photos, I'm pleased to say. This was publicly available if you knew where to look. Did this guy have any reasonable expectation of privacy here?
I don't see it. I mean, this is public record, and also this idea that, well, I didn't kind of, I was also kind of saying, well, I didn't completely get this. I mean, there's typically when you have a contract, which is that's kind of what this is. When you have a sophisticated, he's a judge, he's a lawyer, he's represented. I think Michael Downey represented him on this as well.
One of the best ethics attorneys in town.
So I just don't see what he's complaining about myself.
And we should mention that the people who are on this judicial commission, they have now fired back in a filing of their own. Here's a quote from it. At no time did Judge Thornhill or his counsel mention that Judge Thornhill wanted his letter of resignation and the exhibit photographs of Judge Thornhill while dressed as Elvis on the bench kept confidential by the commission or filed under seal with the Supreme Court of Missouri. They're saying there's just not a chance he should have known that. And yet, on the same hand, he's sort of alleging this conspiracy that the presiding judge wanted him out. Nicole, do you think there's possibly any truth to that?
Yeah, I don't know whether there's any truth to that or not, but what I was going to say is that I think we're all up in arms about these Elvis photos. We think that's what's made it, kind of interesting and goofy.
Oh,
and,
it's funny.
Right, and that's what's made it a good news story. But I think, there were other allegations in what Judge Thornhill has done that are much more serious, which is, influencing politics from, political votes for himself from the bench. And, I myself have been in Judge Thornhill's courtroom, and I have heard him say some things from the bench that, in my opinion, were not appropriate. I think there are much more serious issues involving Judge Thornhill here than the dressing up as Elvis. In fact, when I first read this petition and I saw the Elvis stuff, I was thinking, oh, this actually makes him sound like it's a little sad here that they're going after him. He was just trying to be this fun-loving guy. But there are actually much more serious issues involved in here in the other counts in the disciplinary petition and even in things that, he regularly does.
Yeah, in his own filing, trying to make his case that he was treated badly, he references the matter of, at one point, he left a gospel tract on the car of a lawyer. Like, the way that I took this is that potentially trying to proselytize to a lawyer who was practicing in St. Charles County. Javad, that seems like a big deal. That seems like something we can't have our judges doing.
That and asking people who are in front of him, did you vote for me? Do you have a sign for me? And it's kind of crazy. I think I looked. He won re-election by like 90%. And he's still doing all of this stuff. And I think I read at one point he had allegations that he was telling people to hire different vendors. And you've got a lot of power when you're a judge. And basically saying, I will look at your case better if you do this. If I were him, I'd be very happy about the Elvis thing, because everybody's talking about that and not talking about all of this other gross stuff under there. But that's not what I think is the grossest thing about this case. The timeline. So it looks pretty clear that the Supreme Court found that he does not have the right temperament to be a judge. He negotiated a deal. I don't know of any position in the world where my boss could move to fire me. A panel can decide that I should be fired, and then I make a deal that says, well, can I just go on vacation for a few months, then come back for 18 months, do my job, and then I'll quit. And then the taxpayers are going to have to pay my retirement for the rest of my life.
And what's crazier is now he wants to undo it. He got that sweetheart deal, and now he wants to undo it. Yeah. He should be happy with what he got.
And I do want to make clear here, because I have heard from people who work with this judicial commission. It was not the Missouri Supreme Court. It is this judicial commission that is a separate deal that regulates judges. But yes, your overall point.
But eventually all of this gets put in front of the Supreme Court, and those filings that you very well bragged about how good of a reporter you are on CaseNet under the Supreme Court. So I can go and look at that. And then here's the other thing, and this is something that I bang my head against the wall with the city of St. Louis. They hide stuff all the time, and they try to get protective orders all the time. And their general argument for their protective order isn't that this is confidential or this is, protecting some child. It's, this is bad for me and it looks bad. I don't want people to know that my client did this bad thing. Protective orders are very limited. They're supposed to protect Social Security numbers, medical records.
Victims, maybe.
Victims.
Secrets.
Right.
Yeah.
I don't know what even if he had asked for this to be confidential, Like, I don't.
He's a public official.
Yeah.
We should
Right.
know, right?
Yeah,
You know-
I'd like to believe if he had asked for it to be confidential, they would have pushed back and said that's
One would
not
hope.
right.
100%.
Yeah.
Later on, we're going to be talking about another public official who is trying to hide materials. This idea that you could use your power as an attorney to hide bad stuff, it's quite simply, for the second time today, gross. He did something bad. I should have been anybody should have got this publicly. If not, if they'd put it under a protective order, you would have been totally in your right to sunshine this. This idea that I did something bad and you broke the rules because you told people, come on.
So, Nicole, you mentioned the experience you had working with Judge Thornhill, and I will say, based on my inbox, it appears that this was something of an open secret in St. Charles County, that this courtroom was an erratic place to be at minimum. What sort of recourse does your average attorney have if you're regularly practicing in a jurisdiction? Let's just make it hypothetical, any jurisdiction that you're regularly practicing, and a judge does something that seems beyond the pale.
I mean, it's pretty tough, right? Because no attorney practicing in front of a judge wants to get on the wrong side of that judge. So it's like that old saying, which now, of course, I can't remember exactly how it goes, but if you're going to shoot the king, you better be sure you kill him, right? Because you don't want to then take the ire of that judge if that judge is not removed. So, yeah, no, the judge has a lot of leeway there, and it's a great responsibility.
You can see why the presiding judge might have had a vendetta, even if that vendetta was simply wanting him out.
As attorneys, we have a duty to report misconduct. Judges have that duty, and I've never had to do that, but I can imagine a situation where I would have to do it, and I would think, I don't like this person. It's no problem. And other times where you like some person, and you have to do it grudgingly, and so. If this person is not a good judge, and from what I've heard, there were other issues, then
yeah. Javad?
And I think you made one other good point. This is St. Charles. If this were St. Louis City or St. Louis County or Jackson County, where there are dozens upon dozens of judges, sometimes the way that the presiding judge deals with this is kind of sends the judge off on a special project. St. Charles doesn't have nearly that number of judges. If you have a judge sitting there, they have to do cases. Now, he's been moved off of the normal docket, the criminal docket, to the adult abuse docket, but that's still a very serious docket where you can't just put him off on a special project, where if you've got 70 judges like we do in some of these counties, you can. And if this could have even been worse. Some of our circuits have 3 and 4 judges. So when you have somebody who's going off the deep end, I mean, I would say if I were in front of this judge, the most probably logical thing for me to do is to walk in blue suede shoes and a loose-fitting suit and, start quoting Elvis to get him on my side.
I can see you doing that, Javad. That's
I have
the
blue
thing.
suede boots.
I also believe that.
But like you were mentioning before the show, in St. Charles, they elect the judges. And in most counties, or many counties in Missouri, we have the Missouri plan where you have this commission that interviews and sends 3 names to the governor. The governor appoints them. They're up for re-election. They have to be retained. That is probably a better, I think, I wouldn't say problem. I think it's definitely a better system to get better judges who are well-qualified, well-suited, as you said, have the temperament because this is a serious thing, and we want serious people doing it.
I would disagree on that.
You like
I
elected?
like the idea of judges applying to a panel and being recommended by the panel. I don't love the idea
of the
that
governor.
the governor then comes in and says, I'm going to pick the person who is most in the pocket of the police union. And I don't like the idea that this, for some reason, only applies to us, St. Charles, St. Louis County, and Jackson County. So where the progressives are and the Democrats are, we have a different set of rules, and then every place else can do things differently. It goes into how we pick our sheriff, how we pick our circuit attorney. Why do we get separate rules than anybody else?
It's interesting. I normally hear conservatives complaining about the Missouri plan because they feel like this has kept, more sort of like middle of the road people in office versus the, the sort of
who's in the governor's office, I think.
Yeah, but lately I've been hearing a lot of conservatives complaining about it. So it's interesting that a progressive, I think, would also have some complaints.
To the point that the governor, I'm fine. Having professionals interview people for professional positions makes all the sense in the world. When you push in the politics towards the end, well, then what are you going to do?
So let's change gears here. Judge Thornhill isn't the only one fighting to keep his status. Former St. Louis Circuit Attorney Kim Gardner, she's battling to keep her law license. She previously entered a diversion agreement with prosecutors to avoid charges being filed against her. She basically admitted that all of the charges that are now being brought by the Office of Chief Disciplinary Counsel that governs Missouri lawyers, that these are true. So I guess the big question is, why are we here? She's fighting to save this law license. Nicole?
I mean, I want to be very clear that when you do a deferred prosecution agreement, you have to admit all of the facts. I mean, that's part of the point, is that then if you then violate down the road, that the government can then bring those same charges against you because you've admitted all of the facts. It's essentially a pre-criminal charge plea deal. So you have to admit all of the facts. It's written out extensively in the agreement, and you're stuck with it. So, yeah, this is nonsensical.
And adding to what's weird here is she doesn't seem to be in Missouri. She doesn't seem to be practicing law. She's, she's pursuing this nursing plan. But yet, we had this one-day hearing. Seemed like a pretty wild hearing. At one point, Kim Gardner's own lawyer called himself as the witness. Mark, have you ever heard of that?
No. Well, he had somebody else interview him. Yeah, but I've never heard of that. It seemed to me that what she was basing her kind of defense on is, well, she took money from the, I guess, circuit attorney's budget to pay fines.
Her personal ethics
fines, yeah. And she relied on the judgment of an attorney, Michael Downey, who we mentioned before, who does a lot of ethics work. But, and I couldn't tell from the reports whether he said this is a draft opinion or this was a final opinion, and so, whether this reliance is...
I have an answer on this,
yes.
So this is from St. Louis Magazine's reporting. After much back and forth, Downey testified that he couldn't recall one way or the other. He said he sent the letter for, quote, review and comment. He also said it's his custom to provide clients with a draft legal opinion ahead of a final one, but nobody can seem to prove that he ever sent the final one. Does it matter if it was a draft opinion?
I think so, yeah. I mean, because, it's like, I'm thinking about this. What do you think? And who knows what the draft one said.
Whether he would actually stand behind it in that final thing. Nicole?
I mean, just another interesting fact that I think a lot of people don't know, though, that shows that I think she knew she was doing something wrong, was that she was paying the checks to pay the fine, and then having the circuit attorney's office reimburse her. So she didn't have the nerve to have the circuit attorney's office directly pay the fine. I think that shows some
You can see
knowledge.
how Hal Goldsmith, the federal prosecutor on her case, would have said, I think I can use this fact pattern here.
Yeah.
And I think there's another point to this. I've got the agreement pulled up, and it's titled Agreement for Pre-Charge Diversion. So in my time, when I was in the prosecuting world, I was more in the terrorism world, but I've seen these before. And often this means that there were 3 or 4 other things that they might have been able to charge her with. And in the agreement, they said, you know what, we're not going to publicize 1, 2, and 3. We're going to do the one that we all agree upon. So there may have been more significant possible criminal ramifications for her when she decided this. Now, I find this interesting because we've got the parallel to what's happening today in St. Louis County. You have the county executive who's decided he's not running for re-election.
Sam Page just announced this morning, for those who had not yet seen the news, he will not run for re-election. Her case involved $5,004.33. His case involves about a little bit less than $5,000 about using funds for possibly political advertisements. His defense is, I took this to my lawyers, the county counselor's office. They gave me opinion that said it was fine. So I don't know how that plays out, but eventually one of the things that I think is right that Nicole says is when you decide to take that and get that extraordinary step,
Hal Goldsmith, when Hal Goldsmith shows up, if Hal Goldsmith shows up in my office one day and says, Javad, I need to talk to you, I'm just packing my stuff up. I'm telling my wife it's done.
Hal Goldsmith, is a very good lawyer, a very good prosecutor, doesn't goof around. He doesn't have an agenda except I'm going after bad guys. So if
one of the 4 people that the Riverfront Times picked as best attorney in St. Louis, along with me,
I think he has just an excellent reputation and is really good.
Somebody got his mic. I'm just asking.
Yeah.
No, but I'm saying that when this happens and you plea and you take this and you're not serving any jail time, this kind of feels like what we were just talking about with the Elvis judge. You got a big... you're not going to jail. This is great. Cash in your chips. And then all of a sudden you're I'm pulling everything back and I'm going to let it ride again. Sometimes the best thing you can do, and we talk about this in court all the time, when I know I've won with the judge, I just need to shut up. Cash in your chips and go home.
We do know that is very hard. So that's,
we're very good advocate.
We appreciate that. But I do wonder, I think you make a couple excellent points there. But going back to this idea of my lawyer told me I could, whether that ends up being, let's say Michael Downey, sorry. I act like I know him, I don't. Let's say it was a final opinion, not just a draft opinion. Let's say for Sam Page, he relied upon the advice of the county's lawyers. Is that a good defense?
I don't think it's a complete defense, but it goes to your state of mind, and that's when her attorney/witness was trying to say this is all about state of mind, and she had this opinion, so you can't hold her responsible for that.
Yeah. What's the thing that the average person breaks the law, a dozen times during the day? We have to be able to rely on lawyers. It feels like that should hold some weight.
It should. And this is where I think I would distinguish the St. Louis County executive's position and the circuit attorney's position. I do think it is very fair for people to say, I depended on my lawyer, especially when you have a lawyer that is this well-renowned as Mike Downey. The difference is Sam Page is a doctor. Kim Gardner is both an attorney, and she was elected as the premier top law enforcement attorney in the area. For her to make the argument, I didn't know, falls into the same camp as the judge saying, I didn't know. I would hold an attorney to a higher standard on that. I don't know if this is going to end up in a suspension or not. I can tell you that all of the allegations that were against Kim Gardner that eventually were the basis of her resignation about hiding things from judges, about not telling the truth in court, about doing all this, all of those taken as a whole, I'm not so sure she should be an attorney anymore. I wouldn't hire her.
We're talking today to our legal roundtable. That is attorney Javad Kazali. We're also joined by Nicole Gorofsky and Mark Smith. We need to take a quick break. When we come back, a state senator settles with his accuser again. This is St. Louis on the Air on St. Louis Public Radio. Welcome back. I'm Sarah Fensky. I'm the executive editor of St. Louis Magazine. I'm here for my once-a-month hour hanging out with top lawyers, talking about all the important legal matters in the news. This month, we're joined by Mark Smith, who's one of the founding attorneys of this legal roundtable, Javad Kazali, who's with the St. Louis firm Kazali Wersch, and Nicole Gorofsky, who's a partner at the Clayton firm Frankel, Rubin, Klein, Payne, and Podlowski PC. Starting to get that one down.
You're getting good at it, Sarah.
I'm working at it. So State Senator Steve Roberts, he has settled his lawsuit with a woman who accused him of assault, and he's settled with her again. This woman, named Amy Harms, she has come forward to have her name out. She accused Roberts of assaulting her at a bar. She sued him back in 2017. They settled. He later claimed his family, quote, didn't pay a dime to settle the lawsuit. Well, it later came out that an insurance policy had paid Harms $100,000 to drop the lawsuit. So Harms then sued him last year. She said that the senator's claims about no payment was deliberately misleading and violated the terms of their settlement. And that settlement had barred either party from making public statements about it. So now they've settled all over again, and we will likely never know the terms of this. Maybe everybody learned their lesson from last time. But I want to just get into a little speculation. Do you think a statement like that would violate an agreement not to make statements? Javad, what do you think?
100%. All right, this idea that you negotiate something where you pay to not have somebody talk. He paid for her silence, okay? This idea that you could say, oh, I didn't pay anything. I mean, it was my insurance company, but that's not me. That's why we have insurance. This would be like Bear coming out and say, well, we've never paid anything because AIG paid all of our stuff. He took the first shot on this, and she absolutely gets the chance to respond. Not to go back to a time that you and I were together, but I think the most trouble I've gotten into on this show is I had done a mediation against the city, and while we're sitting on the show, you read me a quote from the city about what had occurred. It was totally false. And
you went nuts.
I went nuts.
I'd forgotten about that.
Right. And I got nuts because we'd done it in a mediation. And then they had the nerve to come back and you weren't supposed to talk about the mediation. I was like, you put out a public statement to Sarah Finsky to read to me, and then you're shocked that I responded. He went out and essentially lied and tried to make it like he paid nothing. And then once again, let's go back to this. He's an attorney, okay? He claims, I had no idea my insurance company paid. Come on, And then for him, he said this for a reason. I paid her nothing. The point of that is, I did nothing wrong. I took no liability. She made this up. She's out there doing this. She was so clear that this was not real that she ran away without a penny. And she said, weird.
Yeah.
I'm looking at $100,000. Come on.
Nicole, you've represented a number of sexual assault survivors, and it feels like these NDAs are very common, and they're usually not to stop the person who settled from talking about it. It's to stop the person from talking about it. But in this case, it seems like it backfired. Have you seen that happen before?
I mean, yes, I personally, as an advocate for sexual abuse survivors, hate NDA agreements, right? I think victims should always be able to talk about what has happened to them in their lives, and I don't think anything should stop that. And I think it also is the reason why abuse perpetuates, which is why, like, for example, in the Catholic Church, why we've had so many years and years of silent abuse, because people have signed these NDAs. So that's my soapbox about I don't like these at all. But I 100% agree with Javad. I mean, this guy, I mean, it's just completely violated the agreement. I mean, you can't say this. 100% the implication was supposed to be, I didn't do anything because I didn't pay her a dime.
I was
which
vindicated.
Is, patently false. Yeah, I know it's rare that I agree with Javad.
But the moment has come. All right, changing gears here because there's a couple more matters I'm hoping we have time to get into. A new Missouri rule went into effect this month that requires age verification for pornography. In response to this rule, Pornhub shut down operations in Missouri. Other porn purveyors now require anyone viewing their material to share personal information proving they're an adult. Not the first thing you want to do when you're out there surfing for porn. So, Javad, what caught my eye on this is it wasn't passed by the state legislature. It came out of a stroke of the state attorney general's pen. Can they just do that?
I mean, I guess she can. The question is what kind of force this has. And it's not just that the state legislature didn't pick this up. They've tried, and they don't have the votes for it. So Pornhub left on their own. Now, because I'm a very diligent researcher, I have done my research, and I can tell you that there are a lot of sites still up in St. Louis that require no name, no ID.
We will not ask you to list those sites.
I will not, but I will. But it'll be interesting to see if the Attorney General backs herself up and goes after them and tries to charge them in some way, and they challenge that. But
because then they could maybe have a challenge to say this was not enacted by a legislative body?
Like, using this precedent, she could write something on a sheet of paper that says nobody's allowed to wear blue blouses. But and this, I also say this idea that kids don't know how to use VPN, like they do.
Sure.
Even I know how to use VPN.
My daughter taught me how to
I
use
don't know how to do
VPN.
anything.
I was in a hotel room in Rome watching the Illini play in the NCAA tournament.
When I'm in Beijing, that's the only way I can read the New York Times. I get a VPN.
Because they block it there in China.
But this is just another example of the politicalization of the people who are supposed to represent us. If you want this passed, put it in front of a legislature and have them vote on it. And when they failed to do this, having a single person who, let's be 100% clear, wasn't even elected. She's a replacement. And for her to say that she's got the power on this is red meat politics.
Nicola?
Yeah, I mean, she's claiming she gets the power from this Missouri Merchandising Practices Act, which is this act in Missouri where there's kind of an iteration of it in every state. But it's basically a consumer protection act which allows people to sue for, like false advertising and things like that. She's claiming that this is somehow an extension of her power under the Missouri Merchandising Practices Act. So she's trying to not say it's the blue shirt thing. She's trying to tie it to something. But I think it's a pretty weak connection. And we are, I believe, the only state that has made, who has, done something like this. In Texas, there was a Texas case that went up to the Supreme Court that the Supreme Court said, okay, Texas, you can do this. But it was actual legislation. And so here it is not actual legislation. It's this kind of tenuous connection to this possible power the Attorney General has.
We're going to go from porn to panhandling in our final 3 minutes here. So the city of Des Peres has a new law that aims to stop panhandling. Attorney Beavis Schock, sometimes a panelist here, he previously won a lawsuit against the county's panhandling laws. Now he's back with a suit against Des Peres. Mark, this one is a little different because they banned all solicitation of money in roadways. Does that mean it could hold First Amendment muster here?
It's more likely to. So just because I think most people don't get this. The Supreme Court has said soliciting donations for a charity, that's free speech. That's a protected right. And they have not extended it to soliciting for myself, but a number of circuits have, and I think that would be a protected speech. So I know a lot of people think, that doesn't sound like speech, but it is. And so, but you can still have restrictions on speech. They have to be narrowly tailored to this compelling government interest. So here the question is going to be, you'd have to ban everyone from soliciting. So you can't have the firemen out. You can't have some Girl Scouts selling cookies. And it's got to be, for safety, safety of the driver, safety of the people out there on the middle. Obviously, you could say, well, you can't solicit in the middle of a highway. So the question is going to be here, and I think they'll be looking at facts like, well, what were they talking about? Were they talking about panhandlers, or were they talking about safety issues? That could go to.
So when they crafted this legislation,
I think this could all go into it.
Okay. Yeah. If it suggested their intent was to shut down panhandling, they could be in trouble?
I think it more likely be
Interesting. Javad?
I mean, I think as written, without looking at the history, it's a content neutral
I think
rule.
It is right now. Yeah.
But I think you get to look at the past. For decades, Des Peres, Chesterfield, Creve Coeur allowed the firefighters out there, allowed the schools, allowed the police officers, allowed everybody. The only people that they went after were the panhandlers. Then when they were told they can't do that, then they said, actually, the years that we let all of those people out there, that was a mistake. We shouldn't have. We were really concerned about their safety too, so we're getting rid of this. And on its face, when looked at the context, it's pretty clear that what they decide is they want to get rid of the panhandlers, and if they've got to get rid of everybody else, we're going to do that. And it's not about safety.
So that's something that maybe a judge would be like, I don't know. You can't just have that motive.
Yeah, I mean, the counterpoint to that is that people overall don't love the idea of people coming up to them, standing in the middle of the street. I mean,
it slows traffic. It's unsafe.
It's dangerous. We have.
I was amused to find out Beavis Schock wanted to make his arguments before a jury, and it turns out he can't because of how the statute is written. I'm thinking a jury would hate panhandlers. No.
So this
in our
is something,
final minute here.
Okay, this is something that I think is, to use my word again, gross. Okay, the statute allows you to go to jail That is an option. Okay? So you get a jury when there's the risk. And this has happened in the city, and we've won this in the city on protest cases. When the prosecutor comes in and unilaterally says, I choose not to send you to jail, prosecutors have no power over judges. A judge could still do it. So the prosecutor can't, and I think it seems like it's working, but the prosecutor saying, I've decided that I'm not going for jail, that's not what the rule should be. Statute says jail, you get a jury. And Beavis may have a reason for this.
Beavis may know juries love Beavis. You know, we can see the charm of Beavis Shock, that he may understand that that's his best play. But it sounds like he's not going to get a jury. He's getting a judge.
I'm going to send him the ruling that we got in the city that determined that he would get a jury, and hopefully that can work.
Maybe we'll see this fight go on. Javad Ghazali of Ghazali Wersch, thank you. And attorney Mark Smith, thank you.
Thank you.
And Nicole Gorofsky, thank you.
Thank you.
This episode was produced by Sarah Fensky.
Our audio engineer is Aaron Dorr. This podcast was mixed and edited by Aaron.
Our executive producer is Alex Hoyer.
St. Louis on the Air is a production of St. Louis Public Radio. Understanding starts here.
Do you find yourself regularly listening to episodes of St. Louis on the Air? Suggest us to a friend you think might enjoy our conversations. And leave us a review and rating on Apple Podcasts on the App Store. It's the simplest way to help people discover our show. Thanks.
St. Louis Public Radio is a member-supported service of the University of Missouri St. Louis.